Welcome to the World Trade Webcast. I'm Greg Sandler, president of ThinkGlobal.com, the B2B marketplace for global trade leads. Today on the World Trade Webcast, we'll focus on the ICC's International Court of Arbitration, commonly known as the Court, which comprises more than 100 members from 90 different countries.
Well, what we do, a number of things, very practical things like arbitration. We have the biggest international court of arbitration in the world. What that means is that companies, when they sign contracts and they say, have a clause, an arbitration clause that says basically if we disagree on something eventually, then we will refer this to the Court of Arbitration of the ICC that handles about 2,000 cases every year.
The court is one of the world's most well-known international arbitration institutions. Working closely with its secretariat, the court's primary role is to administer ICC arbitrations. It performs those functions entrusted to it under the ICC rules of arbitration and continually strives to assist parties and arbitrators to overcome any procedural obstacles that may arise. ICC is a leading provider of dispute resolution services for individuals, businesses, states, state entities, and international organizations seeking alternatives to court litigation. It's not necessary to be a member of ICC to benefit from its dispute resolution services. In fact, any and all parties who want to take advantage of these services may do so. Established in 1923 as the ICC's arbitration body, the International Court of Arbitration pioneered international commercial arbitration as it's known today. The court also has developed dispute resolution mechanisms specifically designed for business disputes in an international context. Such disputes pose unique challenges, usually because the parties will be from different countries, implying varied linguistic, legal, and cultural backgrounds. The court provides those parties with a flexible and neutral setting for dispute resolution. It also offers confidentiality and extraordinary freedom for parties to choose the framework used to resolve their dispute. While the dispute itself will be reviewed by an independent arbitrator, the court supervises the process from beginning to end, increasing the quality of the process and the enforceability of the awards.
And one of the main activities of the ICC is dispute resolution. And as you just already mentioned, it is actually conducted by two different departments. One is the ICC International Court of Arbitration, which, as the name suggests, deals with all the arbitration proceedings. And the other one is the International Center for ADR, which deals with all dispute resolution that is not arbitration. So mainly mediation, what we'll be talking about today, as well as expertise and dispute boards and docdex proceedings and some new generic top-level domain name cases and other things.
There are no restrictions as to who can use ICC arbitration or who can act as arbitrators. In fact, this is reflected in the increasing number of nationalities represented. Since its inception, the court has administered more than 19,000 cases involving parties and arbitrators from 180 countries. And a 2010 research survey by the School of International Arbitration at Queen Mary University in London concluded that ICC is the most widely used arbitration institution in the world, with 50% of respondents preferring ICC to other options. The survey underscored that arbitration is a voluntary and consensual process and is widely used for the resolution of international disputes. For more information about the ICC dispute resolution services, visit ICC's website. And please join us on Monday when we'll look at the U.S. International Trade Commission. And for our latest schedule of upcoming Think Global webcasts, subscribe to us with any of the links below and bookmark this page. All of our previous episodes can be found right here at thinkglobal.com/webcast. And thanks for watching.